process of early termination all starts with probation's input. The process really can't get out of the gate until the judge knows directly from probation that the probationer is in good standing. And this means, look, no violations pending, and the probationer's completed all the conditions. That is where the process starts. We need written proof. Nobody gets off probation early without proof from their probation officer that everything checks out. Now, it's important to note here, however, we do not care what your probation officer thinks. We don't. They don't have to agree to this, but they're the only ones that can assure the judge that you've done what you're supposed to do. And that's an important part of this process. If probation does agree to early term, well, that's a bonus, but it's not necessary, and it doesn't even mean you're going to get it. On many charges, they're not going to agree as a matter of principle. Like if you have a sex offense, they're not going to agree to early term, even if secretly they do, because it's their policy to object. But don't worry. I mean, probation officers are not the judges. Don't sweat it. Now, once we have written documentation from probation, the process moves on to the prosecutor. We need the prosecutor's written input. Again, I don't care what the prosecutor thinks. They usually object. But we need their input in writing because they're the ones that must comply with Marcy's law. They have to reach out to the victim. And the judge can't give you early term under Marcy's law until the victim's been reached out to. So we need the prosecutors involved too. And once we have all this in writing, we then get to file the motion with the supplemental documentation and ask for early term. From there, the process depends on your judge, right? Some judges like to have a hearing on this sort of thing, so we'll set up the hearing with the judge and the prosecutor. Other judges don't like to have hearings on motions for early term. They'll just enter a ruling in chambers, granted, denied, and from their desk. The point is, unfortunately, you are not entitled to a hearing as part of your early termination process. So I suggest you get yourself a good local attorney. You're probably sick of hearing me say that. Get someone familiar with your judge. And I wish you luck on your case. Now, if you're looking to get out of probation in Orange, Seminole, or Osceola County, my name is John Guidry. Give me a call. Let's see if we can help you out. Thanks for watching, and take care.